Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments today. I hope you are enjoying Martin Luther King Day. If you're here in the United States, I'm wishing you a great day of reflection and good deeds going forward. Now, I would like to talk about a topic today that's very um, extensive. So, you hear me talking about fixing your status, getting the work permit, and it sounds great, and you want to know more. So, I'm going to tell you more about how I determine whether you can qualify for to fix your status, meaning if you're out of status or you came across the border without inspection, or your stay expired, how can you fix that situation to continue to stay here in the United States, to get the green card without leaving the United States, and also get the work permit in the process? Now, there is a misconception out there, and I think this drives a lot of people to just end up coming and overstaying, um, and then trying to figure it out after. So it's important for you to hear me out so you understand the implications of overstaying or even crossing the border without permission or coming to the border. And while coming to the border and seeking refuge is legal, even though it's such a controversial issue right now, there are very specific criteria that the officers look out for in order to grant you any kind of immigration relief at the border that's going to help you to move forward here in the United States. So I want to talk to you about how you can fix your papers, when you can't fix your papers, and then what to do to figure out your specific case. Now, not everyone who comes here and overstays their visa or comes here on a B1, B2 can get the work permit or can get another type of status. Under immigration law, you must qualify in some way. You can't just say, I'm here, I overstayed, can you give me the work permit? And I think a lot of people make the mistake of overstaying because they think it's going to work. Some people even go as far as to say they have a family member here. They could have a sister here. They could be over 21 and they have a citizen or resident parent here. And they figure that those relatives can just apply for them to get their green card and everything will be okay. So that's not how it works. Once you overstay your visa, once you come through the border, as in you don't come with a visa, but maybe you come seeking refuge to come into the United States. Once you come in without inspection, meaning you sneak across the border, your options become very limited. But nonetheless, a lot of people don't even know what those limited options are. And this is what I help clients with, is that I help clients to figure out how to fix this situation under the limited options that are available. And you would be surprised how many people do qualify for relief. So this is where I say, don't just discount yourself, the fact that you qualify. Don't say that you can't. Okay, it's limited. That means I can't qualify, because I have my clients have been clients that did not think, after going through a lot here in the United States, they did not think they had an option, and we found the option among the limited. So I'm going to list out some of those limited options where you can fix your status if you've overstayed, even if you've crossed the border without permission, how you can fix that. Now, everybody knows about, through family members, but it's not through every family member who's a U.S. citizen or a legal permanent resident that's going to fix that situation, right? So let's talk about family. you're here, you overstayed your visa, or well, let's start with overstayed your visa. You overstayed your visa, um, and maybe you have a sister, a citizen sister. Maybe you have a citizen parent. In a case like this, can they just apply for your green card? The my immediate answer would be, unfortunately, it's not. They can apply for your petition, but it's not going to lead to a quick green card process where you fix your status and then get to move on here in the United States. That if you've already overstayed and you're looking for your sister, your brother, your parents to fix, or even I've even heard situations like babies, but babies, having a US citizen baby doesn't qualify you at all. Oh, okay, so I'm seeing no sound here. Um, all right, so let me fix that situation. Let me know on Instagram whether you can hear me, because this is an important topic. I want to make sure that you can hear me. So on Instagram, I saw one person put no sound, but I want to confirm that there's no sound. So just one person. Okay, so muted. Yeah. All right. All right, let me come out. I'm just gonna fix this situation here and then go back in. All right, so let's go over this again. Let's start. All right, so I fixed that situation. Thanks so much for your patience. Fix that. So now we're back on track here. How can you fix your status? We started with family. How can you fix your status through family members? So let's start off with this. If you have a US citizen or legal, well, US citizen, because not a green card holder sibling cannot apply for you. But say you have a US citizen sibling, can they help you to fix your status here so that you can get your green card without leaving the United States? No. Doesn't matter if you're under 21, doesn't matter if you're over 21. That sibling is not going to be able to help you to get the green card. And okay, so it's saying no sound still. Just let me know. Somebody else confirm. I don't know what's going on with this sound. Just let me know on Instagram whether you can hear me. So a sibling cannot, okay. Yes, so sound is now. Okay, good, good, good. All right. Thank you so much. Thanks so much. All right. So a sibling cannot get you your green card if you're here and you overstayed. If you are looking for your sibling, thank you so much, everyone, for letting me know. If you have a sibling and you plan to get your green card through that sibling, you should not ever overstay your visa. I know it takes 14 years. If you're willing to wait the 14 years and if your sibling is the only person that can get you your green card, do not overstay your visa because it will bring a world of pain, and it's 14 years long. So that is not a quick solution to fixing your papers. Now, what if you're 21 and over and you have a US citizen parent, US citizen or legal permanent resident parent? Can that help you to fix your status here? Same as the sibling situation? No. That is a 5 to 7 year process, and if you want to overstay it, they will not allow you to stay here in the US and get the green card and fix your papers. Now, in cases, I'm just covering those who don't have current status here. I'm not talking about those who have status here. I'm talking about those who don't have status. You're looking to fix your situation. Now, what if you are under 21 and unmarried and you have a US citizen parent? That will be one way to fix your status. If that parent, for any reason, is mistreating you, and that's why they haven't applied for your green card yet while you're here in the US, you can consider applying for what's called VAWA based on mistreatment if that parent is mistreating you, which I don't know of any parent who's going to have their child's best interest in mind, who's going to not make sure that their child who's under 21 has their papers here in the US. So that's usually a red flag for me to know that there's something going on here. If you have a parent here, you're under 21, that parent is a citizen, and they will not file for you. But there are ways to file for yourself if you're being mistreated, and the time to do it would be if you're under 21, in some cases under 25. So if you were in that situation where your parents were refusing to apply for you, now you've reached 21 or over, but that part of that is they mistreated you. As long as you haven't reached 25, you still have a shot at applying for your own green card here in the US through VAWA. Now, what if you are the child who is under 21 and unmarried of a permanent resident? Do you get the same perk where that parent can file for you and have you stay here to get your green card? No, unfortunately not. If your parent is a green card holder, then that means that you cannot overstay your time and get the green card while being here through that parent. Um, no, if, and I know everybody knows this one, if you're the spouse of a US citizen, then that's usually the one that everybody talks about, is being the spouse of a US citizen can help you to fix your status. If you enter the country with a visa, it just you ended up overstaying it or expired, then you can still move forward, stay here, get the work permit, and fix your status. If that citizen spouse is mistreating you, and that's the reason you haven't applied for your papers yet, and you're feeling trapped, guess what? You do have an option, and that's through VAWA. And I work on those cases. I have many of those cases. I represent my clients through the process, and it is well worth it, especially if you're in a situation where you don't trust your spouse to go through the process because they're mistreating you, or they're refusing to go through the process because they're mistreating you, or they're currently going through the process with you, but you don't have any faith that they're going to carry on with the process, then the VAWA is going to be for you here. The same now, if you are the parent of a US citizen and that US citizen is age 21 or older, you can qualify through that child to fix your status, through that adult child to fix your status. But what if that child is also mistreating you, and that's the reason they haven't applied? And keep in mind, mistreatment, when I talk about mistreatment here, it can involve emotional, verbal, financial mistreatment. It does not require you to be, physically harmed or injured or beaten to get this kind of status through VAWA. It also doesn't require you to have the police involved or doctors involved in order to qualify for this relief. And then when it comes to the parent-child situation, there's a lot that can play into this. I know it's complicated because you're the parent here, and the last thing you want to do is apply for something based on the mistreatment of you by your child. This is confidential. Your child will not get into trouble. The goal of immigration here is not to call the police on your child, communicate with other agencies to tell the agencies what your child has done. The sole goal of immigration service is to just look at what is happening to you and provide you the right immigration relief to be safe and to move forward here in the United States without depending on that relative who's mistreating you. So I know, as a parent who's also trying to look out for the interests of your child, A number one fear is that you do that and it hurts your child. But this is confidential. Your child will never, your adult child, 21 or over, will never know you applied for this if you don't ever tell them, which I recommend to, I definitely recommend you not say anything about this confidential process. And the Immigration Service is also bound to confidentiality. So they can't call your child, or they can't call your spouse, or they can't call your parent and say, hey, your relative, immigrant relative, applied for VAWA, and I want to confirm whether this is happening. They are not permitted to do this. This is not a simple policy. This is law, and there are penalties involved if they break that law. So keep that in mind, that it is confidential and it's about your interest. It's about your safety, your well being here in the United States. And they tailor the process to be that way, where you don't have to fear retaliation. You don't have to fear, even the repercussions on yourself to go forward with this type of application. So, when it comes to family, what I've done here is I've shown you the ways it won't work and then the ways that it can work to fix your status. Through family, it can be through VAWA if you're being mistreated, or it could be directly through the family member who then files for you to get your papers, as long as that family member is supportive. But keep in mind that siblings, cousins, grandparents can't do that. No, there's one thing to keep in mind though, and it's called Section 245I. That is an exception where I mean, I can do a whole live on that Section 245I, and I have in the past, but they sort of even refer to it as amnesty. And why? Because it does allow those who say were derivatives on an application, who had previous labor certification and petitions filed for them, those people, if it was filed on or before April 30th, 2001, those people can qualify for Section 245I. That says, even if you're here now, say you cross the border without permission or you overstayed, in that case, if you fall within that category, you can possibly stay here. You can actually, if you do qualify for this, you can stay here and get the green card despite now the overstay and despite crossing the border without permission. So that is an exception. And so anybody can apply for you to get you. An employer can apply for you, your siblings can apply for you, anybody can apply for you. And as long as Section 245I applies, you will be okay to stay here and apply for the green card. But keep in mind, even though, say, your sibling applies for you, it's a 14-year wait. To Section 245I is not going to speed up that 14 years. It's just saying at the end of the 14 years, when your priority date becomes current, that means you're at the top of your wait list. If Section 245I is still effective, then, because they might change the law, who knows, but if it's still effective, then you can use Section 245I to stay here and apply for adjustment of status. So you also have to still keep in mind timelines here, but no matter how long that process is, as the law is now, you're able to stay here under Section 245I to get the green card and get your work permit as you go through the process. Section 245I works if, say, because another thing to mention here is if, say, you're the spouse of a US citizen and you cross the border without permission, you can't apply, you can't fix your status directly like that. If you're applying for VAWA, meaning you're being mistreated by the spouse, you can still proceed that way. But if your spouse is willing to file for you, but you cross the border without permission, then what will happen here is you still have to return to your country at some point in the process to finish out the green card process. So you will not be allowed to stay and get the green card unless you're applying on your own based on mistreatment by the spouse through VAWA. Section 245I would allow you to proceed with adjustment of status through your spouse still. So that is, I've given you a little school in here on some of the ways that some of the things I look out for to determine whether somebody who overstayed or crossed the border without permission can fix that situation and move forward to get the green card, and in the process get the work permit at the same time. So that's family. Employment, that's a big question here. Can an employer help you to fix your status? My straight up answer here is no. It's going to be really short here. No. Your employer cannot fix your situation. If an employer is telling you to come to the US, because I deal with what's called T status for victims of labor trafficking, and a lot of employers are riding on that now. They're, the trafficking, the employers who are trafficking are calling workers from outside of the US, and they're saying to them, come to the US and I'll get your work permit for you. And the immigrant worker believes them because they think they're going to live up to their word. They think they know about American law more than anything else. So why would they be telling them they can't do it when they can? But it's a big scam to get you here and get you in a situation where you're working for them and now you're at their mercy. So be very careful about any employer who is telling you to come to the US first and then they'll get you your work permit, or telling you to come work for them and then they'll apply for your work permit. It does not work that way. So straight up, forget it right now. An employer cannot help you to fix your status. There are two exceptions here. One exception is Section 245I again, that I just mentioned. And then the other is if they can get you the green card, but you won't be able to stay here and apply through the I-601A unlawful presence waiver. Those are the only exceptions here. But one of them still doesn't allow you to stay here to get the green card. And the other one, you have to have a petition that was filed for you, or you would have had to be on a filing on or before April 30th, 2001 to get this. And then there are some physical presence requirements, just depending on whether you were here between us, after a certain timeline. So you have to keep that in mind. Happy New Year, Bisa. All right. So that in a nutshell is the employment. No, they cannot help you to fix status. Whenever we're talking about fixing status, getting work permit, employer can't do anything. So let's move on to the next couple of options that I look out for my clients. And let's talk about the T and the U visa. So if you've been here, and not even if you've been here, because I've represented clients who they've been here maybe a year and they realize that they've been duped by an employer or they've been duped by a family member to come here to the US. And when they come here, they are forced into a situation where they're working for the relative, working for the employer for wages they didn't agree to, or they're for work descriptions that they never agreed to, but now they're at the employer or the relative's mercy. They can't do anything about it. They're sometimes even being mistreated along with that, and made to feel stuck in the situation, like they cannot escape it, or made to feel fearful that of what will happen, the bad consequences that will happen if they leave the situation. And the employer, the relative, the stranger, the person that recruited you capitalizes on that fear that you have. They may know you have nowhere else to go, so they continue to drive your fear by maybe, talking about ICE, talking about immigration will get you, or they may remind you that you have nowhere to go, or they may do things like provide you with housing, but they may restrict your movement. So, you can't just freely go in and out of this housing that you have. You feel constrained. Those do qualify for the T status. If you've been in a situation like this, which I represent many clients who have been through this type of situation, T status is for victims of labor trafficking. Labor trafficking comes in different forms, and this is, the different forms. At the end of the day, what I would say, how I summarize it is, if you were recruited or offered a job, or you were offered a place to stay at your relatives or friend's home, um, and you thought you were maybe offered work, or you were offered, promise to be sent to school, or promised a green card, or promised a work permit. So that's what drove you to go to this person and accept their offer. Then, after you accepted the offer, you find yourself stuck in the situation that you never signed up for. You're doing more work. They're, mistreating you in some cases. They're, subjecting you to work that you find demeaning, that you clearly was not a part of the deal. Or they're giving you ultimatums, telling you, if you leave, all the bad things that are going to happen to you. These are examples of labor trafficking. So labor trafficking is not just situations where somebody's being kidnapped and tied up and they're missing. Your family can very well know where you are. You can have access to your phone. You can still have maybe even the ability to leave the housing at times, but you're still going through a form of trafficking, labor trafficking, or in some instances, sex trafficking. Um, if you find yourself trapped in a situation like this, and you really did not sign up to be in that situation, but here you are, and you are finding it hard, or you're afraid to leave, then the T status could be for you. The T status leads to the benefit of a 4-year work permit, and you will be able to then apply for your green card after the approval for the T status. So it is a form of relief that has given my clients, changed their lives completely. Not only has it changed my clients' lives, but it has changed their families' lives. The spouse of the immigrant and children under 21 and unmarried also get the status along with the relative, the immigrant relative who went through that situation. So I have experienced the indescribable joy of watching children be reunited with their parents, or parent or parents here in the United States. Their children, they were separated from their children because they were in this situation, and now they can all be together as a family. So it's something that is such a pleasure for me to be a part of, because these are clients who had no hope. They just thought they had to get married to get the green card or the work permit, or they had to be sponsored directly by a relative. They did not know that they could have a process, that they could be in control of the process. It is also extremely confidential. So nobody will know about this. It is so confidential that the only way that we get updates from immigration is by mail. If we do have to get in touch with them as a lawyer, we do have an email that we can email them. If we say we have a correction to the record, or we have an update, or some issue that we want to iron out, we can send them an email. However, they will never have a status check, because it's so confidential. They will not take calls about your case. They give us the good news by mail, so we have to wait. Somebody here asked, how long does T status take? So it could take 6 months to 18 months. But on average, I'm seeing 10 to 12 months. Most of my cases are being approved in 10 to 12 months. But well, I don't have control. No lawyer has control over processing times. So I do tell clients to prepare for an up to 18-month process. It opens the door for so much more opportunity for not only the immigrants, but their family members. And so not only does the immigrant get the benefit, spouse, the parent, if the immigrant is under 21, the parents can qualify as well. So this is a reason that if you've been through this, don't wait. Children under 21 and unmarried can get this. If the immigrant is under 21, then their sibling who is 18, under 18 and unmarried can also get this benefit. In addition to that, we have had cases where it's not only just the there's maybe a continuing threat. The levels of mistreatment is differs, and every case is different. But you do have some traffickers that continue to be a threat. So I've had clients where the trafficker continues to stalk my clients or follow them or call them or threaten them or threaten their family members in the country. If family members are being threatened and they're not so family members are being threatened and they usually would not qualify, then they can qualify for T status as well for their own protection. So they get the T status along with their immigrant relative, the main applicant, because of a threat. So that is also available. So they do extend the benefit based on different scenarios, but at a minimum, spouse, children do go along with this. And I tell you about this, I stress this one because so many of you out there are going through situations like this, and you just think you're alone, you have no way out, that you have to continue to listen to what the whoever is keeping you trapped like this, you have to continue to comply with them, and you don't. There is you can change the trajectory of where you're going here in the United States. The T status is one of them. Now, the U visa, that's another way. As a victim of a crime, if you've been the victim of a crime, you can qualify for the U visa. Now, if I had to choose between the U visa and the T visa, always gonna be the T visa because it comes through in a shorter amount of time, and you still get the benefit of then going on to getting your green card after approval of the T. But I have had cases where they didn't qualify for the T, but they were a victim of crime. And in this case, another downside of the U is it does take 7 to 10 years to finally get the U visa. So you have to wait 7 to 10 years to get the green card. Of course, you can be here the entire time waiting for that. However, what the upside of this is that you can still get the work permit while you wait for those 7 to 10 years. So it doesn't mean that you have to wait without any benefits at all. Um, you can get the benefit of the work permit. What we do with this one is for victims of crime, it has to be reported to law enforcement. So if you are the victim of a crime, you reported it. Doesn't mean somebody had to be arrested. Doesn't mean that you had to go to court to testify. It doesn't mean that the police have to have a continuing investigation open. You just have to report it, and then we can ask the law enforcement to get a U certification. The downside of this also compared to the T is the U visa requires that law enforcement sign that certification, whereas the T visa does not require law enforcement to sign any paperwork. So that's also a big difference there. But I have had clients that they qualified for the U, they didn't qualify for anything else, and they have gotten the work permit, and they're gonna be the 4-year work permit still. So still get 4 years, and they're placed in deferred action. It's a type of special permission that's given to them to enable them to stay here for the duration of the U visa process. So it is a good option if nothing else applies. So we've covered, um, through family, through VAWA, through the T visa, through the U visa. And now all of these options that I am saying, that these are ways to fix your status, most, if not all of them, I would say, just being the spouse of a US citizen and crossing the border without permission, you couldn't stay here and get the green card. But if you're applying for VAWA based on mistreatment, even if you cross the border without permission, you could stay and apply for this. So all of them do allow you to still apply for these benefits, even if you've crossed the border without permission. Now the last is asylum, which with asylum, they're implementing more restrictive laws, and they're doing this, and now they're negotiating to restrict it even further. And based on what I'm seeing in the news, they're close to coming to an agreement. And the Biden has expressed his willingness to give up concessions that he was previously standing for, to be able to accommodate the demands of mostly Republican Congress people to restrict immigration. And one of those is asylum, to expand expedited removal, meaning they're going to look for people who cross the border without permission throughout the country, and they're going to take them no matter where they are. They're going to take them and deport them through expedited removal. And they're looking to limit parole. Parole is that special permission that some people get at the border, or if they're processed outside of the United States, to come here because of humanitarian reasons. Now, what that's telling me is that if Biden is willing to do that, then it means that what else is he willing to do as we go further and further into this kind of political climate? What else is he willing to do to please the Republican side? And so we have to be very wary. This is where I say taking action quickly is key here, because we don't know where this is going. We don't know what else can change. So take action quickly. I am ringing the alarm here, sounding the alarm here. I want you all to just be conscious about the tone right now. Another thing, I mean, if you saw in the news, 3 immigrants drowned at the border trying to come across, and the federal government, Biden administration, is saying that this happened in Texas. The Texas National Guard physically blocked the CBP or Border Patrol from accessing the immigrants. So this is telling you how serious things are getting, and how quickly things can change to be ugly come the election. We pray for the best, but plan for the worst, and make sure that you understand what your options are. So with that being said, let's talk about asylum. So asylum is where now the biggest problem I see is, I will do a consultation and the person clearly qualifies for asylum, but guess what? They are looking into asylum too late. Action is key. Being proactive is key, because there is a deadline on the asylum, and you can apply for asylum 1 year, up to 1 year after your entry into the US. So if you're still within that 1 year timeline, you need to think about whether this can be an option for you. Evaluate your options well in advance of the 1 year deadline, because this could be the way that you're able to move forward here in the United States, and apply at a time where you can still apply. We don't know what kind of restrictions they're going to come with, but it sounds like they're coming with some restrictive policies regarding asylum, and the way you enter the country and whether you can qualify for asylum, depending on the way you enter the country. With asylum, if I'm going to put it very simply, because it is a complex piece of law, a lot of it is based on case law, but the general requirement is if you have a credible fear of persecution, meaning you're facing threats, you're facing threats of physical violence, you're facing threats of incarceration or inhumane treatment or torture in your country, because you are either because of your race, your ethnicity, your religion, your political opinion, or any other particular social group. Meaning, any particular social group is, say, any other type of group that's not mentioned in regards to ethnicity, national orientation, religion, political opinion, any other group that you identify with that's facing as a group, you're being targeted, threatened with violence, subjected to violence, subjected to incarceration and torture. You can qualify for this. It does not have to just be political. It can be based on other criteria. And for example, in certain country in Central America, even women who were subjected to domestic violence, who could not leave their marriage, qualified for asylum because they belong to a particular social group. That social group was a group of women who was being subjected to domestic violence by their spouses, who could not escape the situation, and they were not protected by law enforcement or the government or the laws in the country. So in that case, it's showing you that the U.S. Government is open to looking at what kind of group do you identify as, and whether that qualifies as a particular social group under immigration law. So if you can relate to that in any way, go ahead and schedule the appointment so we can get started on your case. Because the way that I'm going to tell whether you qualify and be able to help you is by evaluating your facts. I can't tell you, because one size does not fit all. I can't tell you here that you qualify. And I think the biggest mistake that people make is they just decide that they don't qualify. Take the steps to invest in yourself and determine whether you qualify. I ask the right questions to be able to get to the root of that. And a lot of this is dependent on what have you been through? What are your experiences in the United States? And based on that, I'll be able to tell. So the consultations are very detailed. I ask very specific questions to get to the root of what you qualify for here. So those are whenever you overstay, you cross the border without permission, it means that you have limited options. But whenever you have limited options, a lot of people, wherever they have limited options, they don't know about those limited options. And because of that, opportunity passes them. The other good thing about for example, the asylum has a deadline, but the good thing about the T and the U is they don't have deadlines. VAWA does not have a deadline unless you got divorced. If you got divorced from your spouse, you have 2 years to apply for this. If the spouse that was mistreating you passed away, you have 2 years to apply for VAWA after the death. If your relative lost their status, you have 2 years to apply after they lost their status. So yes, even if a green card holder was the one mistreating you, they got deported, but you were mistreated, you have 2 years to apply for the VAWA. And it doesn't matter that they're now deported, as long as you apply within 2 years after they lost their status. So give me a call, whether you've been here 20 years, 30 years like this, or you've been here for a year. or you've been here for 2 months like this. I want to talk to you to be able to help you figure out the best option going forward. All right, so I basically gave you a big nugget of gold there. So the steps you can take is you can just schedule the appointment. Go to the link in the profile, and I will go ahead schedule because my schedule is filling up, and I really do want to help you. So go schedule the appointment, and we can talk in detail about your particular facts. Because remember, the information I'm giving you is not personalized legal advice; it's general information. So you want to make sure that you get the personalized legal advice to understand what your options are. Now I'm going to answer questions. I'm going to dedicate a couple more minutes to answer all these questions that are coming in. So put your questions in the comments now, and I'm going to go ahead and answer the questions. So I was married to a green card holder. She didn't file for me to get a green card. How can I go about getting my green card through VAWA? So if you said I was married, my next question would be, are you divorced? If you're divorced, is it still within 2 years after the divorce? If it is, give me a call. Let's talk about what happened between you and your spouse and get going. There does have to be mistreatment of some sort or extreme cruelty. So let's talk about the facts here because a lot of it depends on facts, and get straight to work on your case. Can you put in an expedite request for a VAWA work permit? You can always ask for an expedite request, but keep in mind that expedite requests are granted sparingly, and it really depends on what your reason for the expedite request is. It usually has to be based on an urgent humanitarian need. It needs to be maybe show that you need to show a mistake that immigration made that now justifies it to be expedited. I know during the COVID, they were expediting requests for work permits for healthcare workers and childcare workers. And it also, if there is something to show that there's going to be a great financial or economic loss, then that can also count as well. What if my parents file for me and I get denied? So right now they're not following the policy of deporting people or getting you into trouble, getting you into further problems if they deny you. But it means that you're going to be at square one. You maybe faced a lot of wasted time and money. So this is where it's important to make sure that process is going to work. Can a green card holder file for an out of status F1? So no, a green card holder cannot. So if you have a green card holder relative, by all means, do not overstay because they cannot help you to fix your status and get the green card while you're here in the US. That's usually reserved to US citizens for their spouse, their children who are under 21 and unmarried, or their parent. Also, just to make it very clear, if you're the parent of a US citizen, if you say a baby, that baby's not going to get your status. So, good day. What about when you come on the border and meet a husband? So that gets very complex because it's going to depend on how, when you came in through the border, what did they give you when they were releasing you? Did they give you parole? If they granted you parole and not conditional parole, but it's like a type of humanitarian parole, then adjusting status may still be possible. If they referred you to immigration court, now you have hearings, that means you're in removal proceedings. And if you do get married, you have to show the court. You can definitely apply for adjustment of status if that spouse is a US citizen, but you have to show by clear and convincing evidence, which is a very high standard to meet. Clear and convincing evidence that your marriage is bona fide, your marriage is real. So you have to be very mindful of that, and it just depends on what happened when you came in through the border. Can an asylum seeker change his or her status to an H1 visa? So if this is H1B visa, it's gonna depend. If you're asylum seeker but you're still in status, as in you haven't overstayed your time, then it is possible. But when you are applying for asylum, you are in a gray area where you don't have status, but you're not exactly out of status, and you're not accruing unlawful presence. So you wouldn't be able to adjust status through an employer, because H1B visa is an employment based visa. And remember, I said earlier that an employer cannot help you to fix your status. So if you've already overstayed, they're not going to be able to apply for you to get your papers unless you qualify for the I-601 A waiver or 245I, Section 245I. Those will be the ways that you'll be able to qualify through an employer, and you possibly no. But you said H1B, which is non-immigrant, so it's a temporary visa. And so I was thinking more along the lines of permanent residence. But with the H1B visa, they have a pilot program in place right now where they're allowing some people to renew their visas, their H1B visas, while being here in the US. But for the most part, what a visa means is you have to go back to your embassy or an embassy outside of the country to get the H1B visa to come back into the country. And so that again means that you wouldn't be able to do that. I was adopted in America when I was a minor. I left without being filed for, but I have the adoption certificate and my adoption parents died. Any advice? This is going to require a consultation. There may be an option here, but I have to understand all the facts here to see what can be done. Can a green card holder file for an out of status F1? So I answered that. What if you don't have anything joint with your spouse? So, um, you know, I always say this. If you are married to your spouse and you intend to move forward with your spouse in a meaningful way, to plan a meaningful life together with your spouse, you're going to have something. You're going to have something to show for it. Yes, some spouses keep their finances separate, but as a married couple that's looking to plan your lives together, what are you doing as a married couple? Um, don't plan out your immigration process like it's a one size fits all. What kind of couple are you? How do you don't have anything joint, but are what are you doing to maybe contribute? Are the both of you putting into bills? Is your spouse giving you money? Are you giving your spouse money? Who's paying the rent? Who's paying the utilities? Do you divide the rent? If you're driving, you both of you might be on the same insurance. So it just depends. But I say it's, and this is where an officer is not going to be very sorry for you when they're denying you, because the officer is thinking along that lines. If you are married and looking forward to a meaningful life together, you're gonna have something to show for it. And this is what you need to look for. How do you prove that you were emotionally and verbally abused by your spouse, especially if you have broken up? So, a very big part of the VAWA petition is the detailed declaration. That is accepted as evidence as long as it provides the detail that the officer requires to understand is credible evidence and that you went through it. Okay, I just moved here in the US last year with my kids. I received my green card, but my kids didn't have it yet. So contact them, find out where it was sent. Um, would that get them in trouble? So I think this was related to the T visa. Um, it's going to depend. I would say in all the T visa applications that I have represented my clients on, and I've done a number of them. I've never had an employer get into trouble unless my client wants that they want justice. But in most cases, this is so confidential that the immigration service and all the agencies that are involved are more focused on the confidentiality and getting you the relief you deserve to move forward in this situation. And then another thing I want you to understand here is that um, you're the victim here. And yes, you don't want anybody to get into trouble, and they tailor this process to make sure that your confidentiality is respected. But you should not be putting your life on hold thinking about if the person that victimized you is going to get into trouble. Um, so, and it depends on the facts here. So, this is where it's important to schedule the appointment. Let's talk, and I can give you an honest evaluation here. Uh, I've applied for asylum, have received my work permit, but having a difficult time financially. Can I apply for housing assistance? You'll need to contact the public assistance office in your state or in your town to figure out if you qualify. Just be very honest with them about what your situation is and your immigration status. Don't claim citizenship. Don't claim to be a permanent resident. Don't claim to be anything you're not, and just let them know, and they'll be able to evaluate your paperwork and determine whether you qualify for any kind of assistance. Can a green card holder getting married to an F1 student who is no longer in status? So marrying a green card holder is not going to fix that. Um, okay. My case has been reviewed from I-485 since June 6, 2022. What can I do? It's going to depend on what's happening here in your case. If it's taking that long, it could be the office's backlog. It could be something that they're pulling up in your background that they want to investigate further that's causing the delay. If you have found, based on checking your case processing times, that you're over the estimated processing times, it's time to make sure that you put in a case inquiry. And, there are other things that can be done. There's the ombudsman, there's getting the congressperson involved. There's also a possible lawsuit if it, if it warrants that. If you're in processing now and the new president is elected and is against immigration, would that affect you and your processing? So it could possibly, because the policies, they haven't determined the policies here, but what I would say is it takes a while for them to change the policies. And you would rather have your paperwork in early and have it on the tail end of the process where you could possibly be grandfathered in to whatever changes, meaning they're not going to apply the changes to you. They're just looking forward. They're applying those changes going forward from the date that they apply. So this is where it's important to take action now, because they are not going to, usually they don't look backwards. They usually look forward from a date. So say a month, 2 months into the new presidency, which would be in 2025, March, they start to make changes. Then at that point, they're saying, okay, as of April 2025, this is how it's going to be. And so get your papers in. It's better to have your papers in than to apply for something that you may qualify for later on and then now be woven into the policy changes. If you're already in processing now, so I answered that. Is the waiver the VAWA when I petition to remove conditions? One of them is VAWA. One of the waivers is VAWA to remove conditions. How long will it take for my consular interview to be scheduled once my priority date is current and my case is documentarily complete? I've seen a year and a half to 2 years. Is it possible to be eligible to work without being in the US? I'm not understanding that one about working without being in the US. Can you travel outside the country on an advanced parole combo card? Yep, that's what it's there for. Whether it's advisable for you is another situation. Do you get anything to your state, anything to state you're in processing, just in case being stopped by enforcement? Or so you have your receipt notice, you have your paperwork. Can you get your green card in 18 months with a T visa? So no, it doesn't work that way. First, you go through the T visa process. That can take up to 18 months. I'm seeing on average 10 to 12 months. And then after that, you go through adjustment of status, which could be another year and a half to 2 years. Normally, there are two ways to pursue the green card. One is to get special permission to apply early. We help our clients to go through that process. And then the other is to wait 3 years on the T status and then apply then. Can you marry when you enter in America from the board? I answered that. All right, so let's go to the YouTube. I'm making my way over, so just bear with me. Thanks for your patience. Um, is traveling, okay, so I saw that. Is traveling with the combo card safe? So I have had many clients traveling on the combo card. That means they have a travel document on their work permit card, and it has been fine. However, with each of my clients, I look at their case, I look at the risk factors involved, and then I tell them, I give them an honest opinion about the level of risk that they face. Now, the risk that they're facing is, will they let you back into the country if you leave? I would say this. If you say you've had a past deportation on your record, you've been arrested for some form of drug offense or something. Say you um, say while you're outside the country, you go for a very long time, say you go for a month, and your case is denied while you're outside of the US, that increases. So I'd say the longer the time you leave, that increases the risk. Um, and if you've had anything in your past. Good afternoon. How can I speak with you? You can schedule your appointment and go ahead, schedule now because time is going by. And as time goes by, my schedule is filling up. I can't even keep up with how many appointments I have. So please make sure we're in February right now. It's not going to get any better. So please go ahead. I want to help you schedule your appointment ASAP. In the event the sponsor sabotages the marriage green card process, how would the beneficiary have knowledge of this? The scary thing is in some cases you may not even know. The ways, for example, my clients who have applied for VAWA have found this out is they just happened to come by the hidden mail. They found the mail that was hidden by the petitioner, and the petitioner wrote a letter withdrawing their application, or they've gotten a decision letter after the interview where they say in the decision letter, the denial usually, that the petitioner, the US citizen spouse, admitted in the interview that it wasn't a real marriage, just to sabotage the process. So the scary thing about it is you may not know um, that they have done this. You may not know what they've said because you don't have access to whatever information they're communicating to the immigration service. This is why my number one recommendation here is, if you have that your spouse is not treating you well, they're mistreating you, they're subjecting you to extreme cruelty, you don't trust them because of this, do not go through this process with them, because if they are sabotaging you in other ways, they will make sure you don't see that green card. And they are citizens. In most cases, they're citizens or they're permanent residents. They don't have anything to lose here. You have everything to lose going into that. Everything becomes a lot more complex, and even the VAWA case becomes more complex. So if you don't trust your spouse to go through this process, participate in the process with you, then we need to talk and figure out if the VAWA is going to be for you. Okay, so I'm seeing a whole bunch of questions here. Reggae Girl, thanks for pointing that out. Can someone with B1, B2 in the USA able to change to EB2, 3 if they qualify? Yes, that's a possibility. Timing is everything here. So very important for you to understand the timing of the B1, B2, like how much time have you been given in the country, and whether the employer can then petition for you in that time. Who come in the US, who come in the US in visitors visa? So I'm not coming with a visitor's visa is not going to get you anything. So keep that in mind. Good afternoon. I'm here for 8 years and I overstayed my visa. Is it possible I can adjust status anyway? Uh, uh it's possible, but you can't just print the adjustment of status application and file for adjustment of status. I just went through all the possible, well, not all, because there are over 21 ways, but I have went through the limited options available to get through adjustment of status. Does involve adjustment of status if you've overstayed. So if you're in this situation where you want to adjust your status, you're trying to figure out your options, this is where you need to talk to me. Because I know I gave you a lot of information, and you're not an expert. I tried to make you aware of these options, and many of you can relate to this, but it's a lot of information that I've given you. So you need to just make sure you schedule an appointment so I can sift out your facts and determine whether there's an option for you. Oh, thank you so much, Christiana. I appreciate that. I was approved for VAWA and I filed for fee waiver for myself and for children. We were approved yesterday. When should we be expecting approval of the green card? So I would say about another year, 6 months to a year after the approval for the VAWA. I am U.S. citizen, and by the way, they're also waiving interviews for the VAWA green card, the VAWA green card. So keep that in mind. I'm a U.S. citizen, and my spouse is F1. We do not live together as she's in university. How do I show evidence of bona fide marriage, and what's the processing time? So under the circumstances as a couple, what are you doing as a married couple? Are you traveling back and forth to see each other? Even though you're not living together, are you sharing in the bills? Even though your US citizen spouse is not physically in the apartment with you, is your citizen spouse or you on a joint lease together? What are your plans afterwards? This is something that can be overcome in the interview, as long as you also show that you're attending different schools and you have a goal of living together, but after you finish your education. So, this is where I wouldn't be able to just tell you what, because I don't know you as a couple. I'd have to understand you as a couple to be able to tell you what the best evidence would be. Is traveling with a green card safe? Absolutely. You want to travel with your green card. So many people want that green card. When you have it, you have a lot more freedom to travel with that green card. Just don't be outside of the country for more than 6 months at a time. How long after EOS or AOS. While overstaying, can you change your status? So I need to talk to you because you have, once you overstay, once you say the word overstay, your options become very limited. Doesn't mean it's impossible, because I have represented clients where they thought it was impossible, and we still turned the impossible to them possible. But I need to understand what your situation is, to figure out if there's an option for you. All right. So finally on TikTok, I'm going to answer these questions, and then I'll work on getting on tomorrow again. But I've dedicated a whole hour and 10 minutes to this, because I know I sometimes can't make it. So it's really been a pleasure. Let's get on to these questions on TikTok. I just approved last Friday my I-485. How long to get a physical card? I'd say a week or two. I'm married when my child is 19. Can my husband file for her? No, not as a stepchild. I filed VAWA, I don't know, I think a year ago. Now they sent me a notice for an interview January. Why, please? So I'm not sure. For the interview I-485. So usually you have to be approved for the VAWA before you get an interview for the I-485. So I'm not sure what's going on. You need to talk to your attorney or call immigration and bring this to their attention. Procedure of getting visa for my niece and nephew to visit their critical ill grandmother. So your niece and nephew have to apply for a visitor's visa. They have to show that they have strong ties to their home country to come to the U.S. Is asylum EAD taking more than 30 days after 150 days pending? So 150 days and then 30 more days until they can issue the work permit. My husband did his fingerprint on February 2022, and I haven't heard back. Is that normal nowadays? So if you're the citizen and your spouse is the immigrant and he did his fingerprint, I'm seeing cases that my cases usually are resolved in 8 to 10 months. My shortest so far has been 5 months, and colleagues that I know have had it in shorter timelines. So I would say that's pretty long. That's going on almost 2 years. Is asylum EAD taking more than 30 days? I answered that. Does previous schooling affect cases studied on F1? It expired and went home, and years later returned on B2. If there's something you're concerned about, that's where it's very important to schedule a consultation. Not usually, but what's going on that you're concerned about that. When I get a decision for I-485, after interviews 3 weeks now. So they might be looking into something further here. Can an overstayed person get a work permit? It's possible, but I spent the entire life talking about the ways, the limited options that the work permit is a possibility. How soon after marriage can file for divorce? That's up to you. It depends on what's advisable under your circumstances. I'd have to know more. Where are you located? We're located in Boca Raton, Florida, but we do represent clients in all 50 states and around the globe. So no matter where you are, we represent you, and we're really good at it. How long does the I-212 waiver process take? So we're seeing a year and a half to 2 years, and yes, it's really frustrating. My mom filed VAWA application for work permit and got a receipt for adjustment of status. Why? Because if she got a receipt notice for adjustment of status, then it means she applied for the adjustment of status. I'm not understanding. I would have to understand the facts here to be able to figure out what's going on. Can I file NIW with 8 years teaching experience and bachelor's chemistry and pharmaceutical sciences? It's a possibility, absolutely. You do have to show that you are going to come to the United States to achieve a goal that's of national importance and substantial merit, that you do have the ability to achieve that goal, and experience plays a lot into that, along with other factors. And then also that it's going to be beneficial to the government to waive that employer offer requirement, or the labor certification requirement. Now, it's possible, but we would have to get to the meat of the matter here. What's your goal? What is the goal that you're coming to the United States to achieve? And will it be considered of national importance? Doesn't mean you have to be famous, doesn't mean you have to invent anything or anything of that sort, but it has to, you have to show how it's going to be beneficial to the United States, how it's going to how is it going to improve the United States, or how is it going to um, be important to the United States? So that's the key there. So focus on the goal, and then the experience and what you've achieved can back up the fact that you have the means to achieve that goal. T visa, what do I need to submit? How is going to be credible without police certification? So this is where I would never recommend you do your T visa by yourself. It is a complex application process, and you want to make sure you get legal guidance here. My mom filed for me as an LPR. She's now a citizen. Will my case move to a different category? Yes, it will, but it's not going to make much of a difference. Both of them are still taking 5 to 7 years. If you're 21 or over, which I suspect you are. I got married when my daughter is 19. Can my husband file I-130? No. So a church retained me against my will and put me to sell wares for them without any for me. Then this definitely sounds like you could qualify for T status. Get in touch with me. Let's talk about it, and let's act fast to get this in. Now, another thing is that there is a cap of 5,000 for these, for the T status. They have never reached a cap in the history of the T status, but this is a type of application that a lot of people are becoming aware of, and more attorneys are working on. So you want to make sure that you act fast. Again, if you do end up say you apply and the cap is reached, you're going to go through deferred action, where they still give you permission to stay here until they can give you the T visa. But that's another reason to act fast here, because eventually they might just reach that cap. All right, that's going to be it for me today. Thanks, everyone, for your time. I am going to be back tomorrow. So just think of your questions. If I didn't get to your question, please make sure that you keep the question and then come back tomorrow. And it's going to be a lot shorter tomorrow because today is a holiday, but tomorrow we're back to work, and so it's going to be a lot shorter. I was very glad I could dedicate this time to this live and give you some important information. I'm looking forward to seeing you tomorrow, so just save your question and ask tomorrow. If you want to schedule your appointment, do it now, do it quickly, because time is filling up. Go to the link in the profile, go to the description in the video below, and then go ahead and schedule. You can schedule your own appointment, or you can call the office by getting the number on the website. The number is also going across the screen. Go ahead, call, and they will be more than happy to help you as well. Thanks, everyone. Have a good day. Bye.